And save this. And we're good to go. Okay, well, hello, everybody. Thank you so much for joining us on Proper Titles Facebook Live. My name is Sabrina Beer. I'm the Director of Digital Media and Education here at Proper Title. And I am joined by one of our real estate attorney friends, Meghan Stokes, who's a real estate attorney in addition to an estate planning attorney, which is one of the things we're going to talk about today. I want to thank you first and foremost to all of you that are watching, whether you're in real estate or you're not in real estate. Thank you for watching today and learning. We're going to be talking about when someone dies, what happens to their real estate, and that goes under the umbrella of estate planning, which is really important to engage an attorney that practices in that area to help you navigate through what you need for your particular situation. So everything we're going to talk about today is going to be very general. And this is not a subject that any of us want to talk about, but it's super important. Without further ado, Meghan, why don't you introduce yourself to everybody?
Hi, everyone. I'm Meghan Stokes with Law Office of Meghan Stokes. And as Sabrina said, I focus my practice areas on real estate law and also estate planning. I'm very excited to be back doing another Facebook Live with you, Sabrina. So thank you so much for inviting me back.
Yeah, thank you again. I love tapping into your brain. So here we go. So let's say that parents, I don't want to say my parents because I don't like to put things out into the world. So there are parents of somebody and they own a piece of real estate and one of them passes away. What happens to that spouse of that piece of real estate?
Yes, so we're going to have to, the favorite lawyer answer, it depends.
Right.
So we're going to look at how the property is owned on the deed when they purchased. If it's owned as joint tenants or tenants by the entirety, then the surviving spouse has a survivorship interest in the property. So the deceased spouse, their interest will go to the surviving spouse. Now, if for some reason there is no designation on the deed that says how the parents own the property, then the default is what's called tenants in common. So if it doesn't say Jane and John Smith as joint tenants or as tenants by the entirety, then the way they own the property is as tenants in common. And if that's the case, then let's say John Doe, he passes, his interest in the property has to go through the probate process.
Okay, we're going to talk about that in just a second. But to back up, so if I'm married and I go and purchase a property and you're my real estate attorney, that's a conversation you'll have with me up front when we purchase this piece of real estate, right?
Yeah, absolutely. Absolutely. With married individuals, what I usually recommend is tenants by the entirety if it's your primary residence, because there's extra creditor protection involved there. Otherwise, most people, I say, will choose either joint tenants or tenants by the entirety. Tenants in common is not as popular for the reason I just explained.
And all of those, just not to keep talking about this particular part of the subject, but all of those are also options for just any two people that are purchasing real estate together, or just if you're a married couple?
Great question. Tenants by the entirety is reserved only for married couples. The other two, joint tenants, tenants in common, are anybody. Family members, friends, still, they could be married couples as well. There's really no restriction like tenants by the entirety has.
So side note, me on my little soapbox, another reason you should always hire an educated, well-versed professional real estate attorney, like with real estate as one of their main practice areas to purchase and sell property with. Okay, let's move on. So now someone's parents, unfortunately, both pass away at the same time. What happens to that property?
There's a number of things that could happen. If they have some planning in place, let's say they have a will, a probate estate usually has to be opened, and then their will would dictate what happens to that property, whether a specific person inherits it, whether it's split among, let's say they have 2, 3, 4 children. Now, if they own the property in a trust, you don't have to go through the probate process. It's a little bit quicker, easier of a process. And then there's also the chance that the parents didn't have any planning in place. So no will, no trust. That's what's called dying intestate. And the state has a plan for what happens to the home in those instances. There's order of succession that the state has in its statutes on who, would inherit next. If you die intestate, you also have to go through the probate process, which is a court process.
I was going to say, talk to me a little bit about probate, because I fortunately have not dealt in my death really in my life, especially related to real estate. So how does the probate process work? So even if both parents don't die at the same time, one passes and it gets left to the other one, and then that parent passes away and they have a will that specifically says where that real estate goes, they still have to go through what you said is the probate process. What does that mean?
So that means the individual listed in their will as the executor has to file the will with the court. They have to do so within 30 days, and they have to petition the court to open up the probate estate. It's a very lengthy process. At the minimum, it's a year to complete. It's public. It's a public process. The will is filed with the court. Personal information on the executor is filed with the court, their address, phone number, same for their heirs. All of that is public record. You could go down to the courthouse, look that up, find out who's inheriting how much. So it's very, very public process, and it can be expensive. I would say a very basic estate that's not going to have any potential for litigation, no contests, relatively straightforward. Costs anywhere from $4,000 to $6,000 to,
What?
yes.
Oh.
Well, a lot of people don't know what to do, so they hire, us attorneys to probate the estate for them. So a lot of that is attorney's fees.
Wow. Yeah. So even if you have a will that clearly states what happens to the property, you still have to go through.
Yep.
Is it like court ordered probate? Is that what you said? Like, is it?
So the state statute requires an executor to open up a probate estate.
Wow. And that could take a year. So if I was the person that received the real estate in the will, I could maybe not sell that real estate for a year.
Correct. It could take that long. It could take longer if there are issues with the estate. We're kind of speaking in generalities. There are instances where, the property could be sold before the probate estate is closed, and that money could be divvied up. But really, that's probably in more instances where there's a lot of other assets. So if there are claims that are filed against the estate from creditors, let's say medical bills, credit card companies, past due utilities, those claims need to be paid. So typically, if there are not a lot of assets to cover the potential for high claims, then that house will need to be held on to in case there are big claims that need to be paid.
Yeah, that makes sense. So during that, let's call it a year, right? And I understand all these are generalities.
Yeah.
But, let's say it takes a year, then is it my responsibility to pay the taxes on that property and the maintenance of that property and whatever other expenses are incurred on that property?
We have to make sure that they're getting paid. The executor is responsible for maintaining the assets of the estate. So you would want to, the executor would want to be the one who is making sure the property tax bills get paid, keeping insurance, homeowners insurance on the property, making sure the necessary utilities are on. We're in Chicago, pipes freeze. You want to make sure the heat is on at a certain level. And all of those would come from the estate could pay for those. But if you have an estate that doesn't have a lot of money in it, then you could potentially have to go out of pocket to, make sure that the asset is being maintained.
So when you said that the executor of the estate would pay to maintain the property, what does that mean? What is in the estate? What does that sometimes include?
Great question. So anything that is in the decedent, that's the legal term for the person who's passed, anything that is owned in the decedent's personal name that does not have joint ownership or beneficiary designation is considered to be in a probated estate. So anything like life insurance, for instance, is a big common one that's not included in a probate estate because it has beneficiary designations. So that passes, over outside of the probate process.
Okay, so let's say that the person that passed doesn't really have a lot of stuff. I'm the executor. Let's say I can't really afford to maintain this property the way that it needs to be maintained, but I'm in probate. What do I do?
So there is an option to potentially skip probate, and it's called a bond in lieu of probate. So those are popular, kind of, what you're talking about there. There's not a big estate. It's mainly real estate. You don't want to have to worry about the holding costs of the property taxes, homeowners insurance, utilities. There is an option to get a bond instead of going through the probate process. And, there are requirements that the title companies will have before they allow that to happen.
And do you hire an attorney for that as well, bond in lieu?
Yes, I would absolutely advise that. There are a lot of requirements that the title company is going to ask for. They're going to want to see that there's really no need for probate before they will approve a bond in lieu of probate. So what that means is they're going to want to see that potential heirs are not minors, because a minor can't legally inherit until they reach 18. So a guardianship process would have to be started in the probate courts. Too messy. Title company's not going to want to take on that risk. They want to see that there's very minimal to no risk of will contests, so potential litigation about who's inheriting what. If people weren't included in the will that would inherit under the intestacy statutes, then that's something the title company probably isn't going to like to see. So if we can show that there's no need for the probate process, this is an option. The title company is going to require a few items, and this is really why I think an attorney is so essential to this process. It really becomes kind of a strategic decision-making process with your attorney, and they'll be able to explain the pros and cons of a bond in lieu. So for instance, one of the things that the title company is going to require is a personal undertaking from all of the heirs. And what this means is they will need to accept personal liability if someone comes forward in the future that says, I was not included, I'm an heir, I was not included, my interests were not considered, I did not sign off on my interests. If an unknown creditor steps forward, let's say your parents had a secret credit card you didn't know about, $10,000 bill, you could be responsible for that, or any claims against the estate. So that personal undertaking as an heir, you're taking on a little bit of that risk in order to forego the probate process. And then we have the bond itself. Typically, the first year is 2% of the purchase price. So the purchase price is going to be what you're under contract to sell. And then second year is typically about 1%. I mentioned earlier that the average cost of a drama-free probate is about $4,000 to $6,000. So if you have let's say a $200,000 house, you want to sell it for $200,000, the bond for the first year is going to be $4,000. Bond for the second year is going to be $2,000. That right there gets you about to the cost of what the probate could be. Granted, there's no guarantees, things can happen, but typically that gets you to the ceiling of what that probate bill would be. So if you have a house that's over $200,000 that you want to sell, it really becomes a weighing of, would you rather pay more to sell it quickly, or would you rather go through the probate process, pay less, know that any claims against the estate are going to be satisfied? So that's why I say it's really a strategic discussion with the attorney.
Makes my head hurt and my heart all at the same time. Making
Yeah.
decisions when you're emotional is probably difficult as well.
Oh yeah, absolutely.
So Is there something that can avoid some of this stuff that we can do early on while let's say if it's our parents, while our
Mhm.
parents are alive and well, that they can do in order to avoid all of this to some extent?
Yeah, you need a plan in place. A lot of people put it off. It's not fun to talk about, especially if you have a lot of people that you could potentially be leaving behind. I mean, I don't like thinking about what happens when I die with my kids, my husband, my sister, my parents. But really getting a plan in place while you're alive. Well, first, that's the only time you can get a plan in place. But it really it provides a roadmap and peace of mind for your loved ones after you're gone to know exactly what your wishes are, so they don't have to try to guess. And a lot of infighting between family members happens because there's that uncertainty. Let's say, me and my sister, we both are, mom told me I could have this. No, mom told me I could have that. And it's really not so much about items at that point. Like there's memories associated with items. There's, like you said, it's a lot of there's a huge emotional aspect going on there. So the more we can plan it out while we're alive for our loved ones, the better it's going to be.
So, in order to, like I always thought prior to getting into title insurance and working at Proper Title and learning about a lot of this, I always thought that just having a will was enough. To say, okay, I want the house to go here. I want the diamond ring to go here. I want this fancy artwork to go here. And all the rest of my money to go to charity or whatever, right? Like,
Yeah.
But that you would still have to go through probate. So is there a way to avoid like probate? Is there something to do? Like I call you up and I say, Megan, I want to do X because I
Yes.
don't want my kids to go through probate.
Yes. The easiest, simplest thing to do is to get a living trust.
Okay.
So a living trust, you don't own your assets personally. They're titled into the name of the trust. So the trust owns them. So for instance, if I own a house, I don't own it as Meghan Stokes. I own it as Meghan Stokes as trustee of the Meghan Stokes Living Trust. My bank account is owned as Meghan Stokes as the trustee of the Meghan Stokes Living Trust. And then inside the trust, you have the terms on how your assets get distributed. You name a trustee who is, similar to an executor. They make sure that your assets go to who you want, how you want, when you want even. The nice thing with a trust that a lot of parents out there will appreciate is you can hold your children's inheritance past the age of 18. You can condition it upon graduation from college if that's important to you. You can say, they get half at the age of 25, the other half when they get married. You can put any sort of limitations and restrictions on how they get the money. If you just had a will and you pass with minor children, the court has to control that money until they reach the age of 18. And then the court just basically says, here's, let's say, $100,000. So you had nice life insurance policy. Here's $100,000. Have fun. And I know when I was 18, I probably would not have spent $100,000 very wisely. So with a trust, it not only is a probate avoidance tool, but you really can save your children from themselves, I like to say. Another thing that I really like about trusts, and it's not just for parents who have children, it's for anybody who wants to make sure that their loved one's inheritance is protected from lawsuits, creditors, or divorce. So I could put, money from my assets aside into a trust, name, let's just say my kids, because I do have kids, but let's say I didn't have kids and I wanted to name my friends' kids as the beneficiaries. I can hold that into trust. It stays in trust for their life, and credit card companies can't come after it. The potential spouses can't come after it in a divorce proceeding if they get sued because they ran into somebody and a lot of damage was caused. the money cannot be taken from, from a judgment in that way. So it's really a lot more benefits to a trust than just avoiding probate.
Okay, so it sounds like
Lots
the
of information.
is the way to go. And I guess, I like to keep these little question and answers to like 15, 20 minutes. So I guess my kind of ending question would be, I'm assuming that like the living trust, like you can, as soon as you have any assets, right, you should form a living trust, because none of us know when the day is going to come, whether it's, some people die way too young and some people live to be 90. And so
Exactly.
we shouldn't just think about our parents. We should be thinking about ourselves. And even if you have or don't have children, if you own real estate, you could leave it to your parents. And then if your parents pass away, you can change the living trust then at that point.
Yep, absolutely.
Okay, so it's something that everybody should, maybe not everybody, but they should contact you or their attorney that practices in estate planning and decide what's best for them and their assets and their real estate and their plan. That's why it's called estate planning, right?
Exactly. Yeah. And I always make sure to fully explain. I'm really big about educating clients. I don't like telling them, oh, you need to do this or you need to do that. I like to explain, here's one potential, here's another potential, pros and cons of each, what makes the most sense for you. And then, I'll answer any questions they have, walk them through any, potential situations, but it's really about what's going to, like you said, what's going to work for them.
Yeah. And then my last thing, just to clarify, is it different from state to state or from county to county, or is it all the same?
Great question. So each state has their own laws that are going to affect the validity of an estate plan. And I will back up just quickly and say an estate plan is not just a will or a trust. It also encompasses financial power of attorneys, healthcare directives. Those two things are very, very state specific. So anytime you move from one state to another, it's always a good idea, if you have a plan in place, to have it reviewed by an attorney in that new state to make sure that everything's still valid. If something were to happen to you, your wishes and those documents are going to be carried out exactly how you want them to.
Understood. Well, Meghan, thank you for letting me tap into your brain.
Yeah, thank you.
Awesome to have you as a resource. So thank you. Anybody here listening on Facebook, I'm going to put Meghan's contact information below in the comments. So feel free to contact her. Both her law firm and her personally are both on Facebook. So feel free to reach out, ask questions, set up an appointment. And standing on my soapbox, if you don't have an estate plan, really, you should start thinking about it. None of us want to think about when our loved ones pass or when we pass, but we have to think about that. So, thank you, Meghan, so much. Everybody have a great day. Thanks for listening.
Yes, thanks, Sabrina. Thanks, everyone. Look forward to speaking with some of you.
Thanks, Meghan.